2, 1.
The Honorable Court of Tennessee is now in session.
Thank you, Ms. Kraft. And on behalf of Judge Bennett and Judge Stafford, we welcome counsel who are participating in this oral argument by live streaming. We will conduct the hearing in the same manner as if we were all together in the courtroom. Each of you have 15 minutes for your argument, and the appellant has already reserved some time for rebuttal. So unless there are some announcements or preliminary matters, I will ask Ms. Kraft to call the case.
We have Elijah Shaw et al. Versus Metropolitan Government of Nashville and Davison County.
All right, Mr. Diggs, you have the floor.
Good morning, Your Honors. May it please the court. Evidence matters, and the Chancery Court erred by disregarding the homeowner's evidence in order to uphold Metro's ban on home business clients. Tennessee case law shows that evidence can be and is used to rebut presumptions of constitutionality. Metro lets thousands of home businesses serve 12 or more clients per day, while Lidge and Pat are still prohibited from doing the same. In fact—
wait a minute, they're not prohibited anymore. This statute's been replaced, right?
Only temporarily, Your Honor. Metro—
Well, it times out or something in a few years, right? And then they examine what to do based on the experience.
2 years from tomorrow, Your Honor, the current ordinance that Metro passed just this summer is set to go out of effect. And in our briefing this summer, you'll notice that Metro refused to take a position as to what happens when that sunset ordinance goes into effect.
Well,
so because
they don't know what the next council will do they?
Well, Your Honor, it's not about what the next council is going to do, but about what will happen when and if that sunset clause goes into effect, as is currently set to happen. We don't know what the law is going to be once that happens. And this might be a different case if Metro took the position that there were no regulation of home occupations whatsoever upon the operation of that sunset clause. But that's not what Metro is saying here. Metro is simply saying that it doesn't know. And moreover, the equal protection claim cannot be moot under any conception because the law does not afford Lidge and Pat equal treatment as short-term rentals, historic home events, specific plans, and daycare homes, which are all allowed to serve 12 or more clients per day.
But
so that means that
that's not the case you tried.
But Your Honor,
try a case where they could have 6 people instead of 12 or anything like that. You tried a case where there were no people. That's a different case. That's not this case.
That's the record we developed, Your Honor. But the claim, which is that we're being treated differently from people who are similarly situated to us, is still true of our equal protection. That's not changed by operation of the new ordinance, which allows our clients to serve up to 6 clients per day.
But 6 is different from 0. That's not the case you tried.
That's in the record, correct, Your Honor. But 6 is also not 12. And so it's not moot for that reason, in addition to the fact that we are closer to—
I don't follow that. I don't follow that at all.
Okay, well, I mean, we have this summer, our clients submitted declarations saying that they expect to be treated the same as short-term rentals and historic home events and all them, and be able to have the same amount of clients as the others. And moreover, the Norma Faye Piles case shows that the standard for mootness, a party asserting that a case is moot by virtue of its own voluntary cessation, bears the burden of making it absolutely clear that the challenged conduct cannot recur. And Metro has failed to meet that burden here because it takes no position whatsoever on what's going to happen when that sunset clause goes into effect, which again, doesn't depend on what the council does. That's what the law says right now. There's a sunset clause, and Metro will not say what the law regarding home occupations will be once that clause goes into effect. So again—
Are you concerned that when that clause goes into effect, the old law comes back, or what?
Exactly, Your Honor. If the old client prohibition comes back into effect, and again, Metro refuses to make clear that that client prohibition will not return into effect in 2 years, then we still have a problem because as our clients testified this summer, they're currently affected right now by the uncertainty over whether they're going to be allowed to serve clients at home in 2 years. Mr. Shaw needs about 3 years to recoup the investment that he intends to make on his studio. And right now it's uncertain whether he's going to be able to do that because, again, as Metro refuses to make clear, it's quite possible that the old client prohibition comes back into effect 2 years from tomorrow, in which case this case is not moot. I'd also like to point out.
Well, in which case this case could come back, but how can we keep going on the speculative notion of what might happen in 2 years?
Because well, two things. First, again, 6 is not 12. And so whatever we can say about the substantive due process claim, the equal protection claim is not moot. And moreover,
did you try the case with what happens if there's 6 people instead of 6 clients?
The record was the record was tried with under a law under which we could serve 0 clients.
Did
However,
Metro try the case where there were 6 instead of 12? No, Your Honor. That's not the case that you're appealing.
Well, no, we're still appealing against the client prohibition, which again, Metro refuses to make it absolutely clear, which is what the Norma Faye Piles case says it has to do in order to assert that the case is moot based on its voluntary cessation. Metro has not done that. And so it's failed to meet its burden of proving that the case is moot. And therefore, this court can and should retain jurisdiction and rule on it. Even failing all that, Your Honor, this case involves important constitutional rights under the Tennessee Constitution. And so the public interest exception is also available under Norma Faye Piles. I don't want to debate that at length, but that also allows the court to reach a ruling on the merits, which
Wouldn't that be an advisory ruling right now?
No, Your Honor, because again, we don't know that the client prohibition is not going to return in 2 years. This would be a different case.
We don't know it isn't either. I mean, we don't know it is, we don't know it isn't.
Right, but we're not the party asserting
They could even change the law. They could even change the law next year. They don't have to wait 2 years.
They could. That would be
We can
true
always
under any.
change the law.
That would be true under any set of circumstances, Your Honor. But
Well, right.
the fact is,
well, go ahead. I've taken up enough of your time.
thanks, Your Honor. I'd like to conclude on mootness. The burden is on Metro to prove that the case is moot. And without taking a position on what happens when that sunset clause goes into effect, this case is not moot. And returning to the merits, it is clear based on this record that it is irrational for Metro to be treating Lidge and Pat differently from the thousands. Again, Metro does not dispute this. There are somewhere between 3,000 to 5,000 residential homes within Metro's jurisdiction that are allowed to serve 12 or more clients per day, while Lidge and Pat under the client prohibition are not. And Tennessee law is clear. This is the Tester case is the best statement of this, that legislative classifications must be based on real differences which make one class really different from another, and that those differences must be germane to the purpose of the law being challenged. And the key piece of evidence in this case is the deposition testimony of Metro Codes Director William Herbert, the key statements from which are encapsulated in our statement of facts at pages 689 through 92 in the record, where he testified that short-term rentals, historic home events, daycare homes, all the businesses that are allowed to serve clients cause more harm to all of Metro's asserted interests than do single-chair hair salons or home recording studios such as Lidge and Pat. That makes this case exactly like the consolidated waste case, which is the one involving landfills where Metro singled out a construction and demolition landfill for a buffer zone regulation while leaving several other types of landfills unregulated. In consolidated waste, the deposition testimony of Metro's Director of Public Works proved that with regard to all of Metro's asserted interest in regulating the construction and demolition landfills, it was irrational to maintain the differential treatment because the several unregulated landfills caused more harm to Metro's interests. In that case, it was things like dust, trash, and noise than did the construction and demolition landfill. So all we're asking for is a recognition that the evidence matters and that this case is just like the consolidated waste case. Chancellor below failed to cite any of the record evidence in her opinion, and that's the error that entitles us to reversal in this case. Specific plans, I'd also like to point out specific plans. On page 50 of our opening brief, we submitted a picture of one of the residential homes that Metro allowed to have a hair salon through its specific plan process. There is simply no difference, and certainly no real or substantial difference between that hair salon and what Ms. Rayner is trying to do in her home. And I see that my time is up. I'll yield the floor to my opposing counsel and speak in a bit.
Thank you, Mr. Diggs. We'll now hear from Ms. Fox.
May it please the court, Laura Fox representing the Metropolitan government. This case is moot. We don't know whether or not people will be allowed to, we don't know how it will turn out as far as what we'll see in 2 years, whether it will be a success, a great success, or a terrible failure. But the council has changed.
What does the ordinance say about what happens in 2 years?
The ordinance says that Section D is going to be struck, which would mean there would be no provision that governs clients coming to homes. But I don't know that that means you can willy-nilly do it all the time. I don't think that that's what that means. I think it means that you probably can't do it unless you're authorized. But I don't think that's a question we have to solve today. I don't think that we have to figure out what happens today. I think what we have to do now is just say, is it appropriate for the court to reach the issue of whether these people can have clients come to their home business when they are now allowed to have clients come to their home business? Maybe they don't like the restriction that it can only be 6 clients, but they haven't challenged that ordinance. As Your Honor said, they could bring a new lawsuit if they think that the restriction to 6 is unconstitutional. They could bring a new lawsuit on that issue, but they have not. What we have now is simply they are able to do the activity that they want to do, which certainly was the emphasis of the lawsuit all along.
Does the ordinance say that in 2 years, Metro will examine the effect of the 6-person limit and either reenact the ordinance or change it somehow?
It does not. It simply says that on January 7th of 2023, the provision allowing clients to visit the home will expire.
Okay.
I have one other thing, a couple of things to say about mootness quickly. And one is that the plaintiffs appellants are relying on the Norma Faye Piles case, but they fail at page 206. It says that when the party asserting the case has become moot based on the cessation of its own conduct as a government entity. So if Metro is saying that the case has become moot, the court may require the opposing party to demonstrate why the proceeding should not be dismissed for mootness. So if the government has stopped what it's doing, then it becomes, the court can make it the plaintiff's burden to say, why should we go forward and review this case? This is not a case of monumental importance, especially in light of the circumstance where the people are being allowed to operate their businesses right now, such that it's not a case where you need to reach this issue. If they're not allowed to do this in the future, they can ask for relief at that time, and the court can take up that case. They can bring a challenge to the new ordinance now if they want to challenge the limitation to 6 people. But essentially what we have here is a classic policy question. Should people be able to, what kind of zoning should people be able to have? Should they be able to have clients come to their home business or not? And they've won that argument after years and years of the council refusing to let people have clients come to people's home for business, they were successful in persuading the council that this is worth having a try. And so I think that that's where we are. The law now allows them to do essentially what they wanted to do. And I think that another relevant case in addition to Norma Faye Piles is the home builders case from 2019, January 2019, where state law had preempted Metro's housing attempt to encourage affordable housing, and that ordinance stayed on the books. But state law preempted it, and this court said that that was moot in that case. Even though the law remained on the books, it was not being enforced because of state law. And so I think that's similar to what we have here. If the court wishes to reach the merits on this, again, this is a policy question. And it easily passes the rational basis test. We have offered pages and pages of rational bases, and former Councilman Todd testified as to the multitude of reasons that he heard from constituents and council members for why they thought this was a bad policy idea at that time, including preserving the residential neighborhoods and also preserving commercial neighborhoods. Essentially, the goal.
The ordinance is essentially a blanket prohibition with 3 or 4 exceptions, right? Is that how it works?
Yes, that's correct. There are a few exceptions, and although the rational basis test is not intended to be a comparison of all the different exceptions, each one should be able to stand on its own. We offered rational reasons for why all those were in effect, and they are very different from having strangers come into your neighborhood many, many times a day. So for example, the daycare exception, you're going to be having the same families come in every day. They're going to bringing their children to the daycare in the residential neighborhood. And it makes sense that you're going to be having, that you would want children not to have to be in a car a long time to go to a daycare. For the historic home events, there's a policy decision that historic homes, that there needs to be an income source to preserve historic homes. And so Metro has decided it's important to allow them to have events in order to provide funding to preserve these older houses. And for the short-term rentals, although they're very controversial, at the time they were initially allowed, there was a lack of hotel rooms in Nashville for the very important tourist industry. And so there was a policy decision made that these were something that was worth letting short-term rentals occur in residential neighborhoods. And really, if you think about what you're doing with a short-term rental, is you're letting someone come in and sleep in a house. I mean, they may have turned into more than that, as far as some people try to have their bridal showers and their big parties. But essentially, letting someone come into a residential neighborhood in order to spend the night is not very different than a residential use, ordinary residential use as a home. So all these kinds of reasons are have their own rational basis, and they don't need to be compared, but they are very different. This is not consolidated waste where we have one landfill has a buffer restriction, but a very similar landfill has no such restriction. This is not the Schatz case, S-H-A-T-Z case that the plaintiffs have relied on, where there was one kind of waste storage and salvage area that had a restriction, but there was another kind of waste storage salvage facility that did not. That was apples to apples. And so I think you can see that those really go to either not in my backyard kinds of motivations that are very obvious on the record, or some kind of protectionism. That's not what we have here. Here we have definite policy that the council had set that said, we do not want strangers coming into our neighborhoods. We don't know who they are or how, we don't want the traffic in our neighborhoods. People have purchased residential properties. They didn't purchase mixed use properties. And so all those reasons made sense, are rational reasons for why you would choose to not allow people to have clients come into your home office in a residential area. And I think that a couple other things I would like to say. We strongly disagree with the plaintiff's assertion that the Tennessee Constitution and the U.S. Constitution have different levels of protection for equal protection and substantive due process. The consolidated waste case, which plaintiffs rely on greatly, it says that the standard is the same. So that's the case they hang most of their case on, and it says the standard is the same. The Riggs case involving the helicopters in Gatlinburg said that the standards are synonymous. And very recently, we had the Brown case, Connolly Brown, who had the alternative financial services building, and those check cashing kind of places have to be spaced apart so that they're not all in one neighborhood. And Judge Dinkins in November 2018, he had that case and issued an opinion for an economic regulation, which is basically what this is, and said that, yes, there are rational reasons for why you would have certain businesses be spaced apart. And he did an analysis of the equal protection clause and an analysis of the due process clause. And that's what we've tried to follow. We haven't tried to follow the oldest cases on the books. We've tried to follow the most recent one in our briefing, which is the Brown case. The other issue has to do with the burden of rational basis. The rational basis has always been to find any conceivable reason, whether it's you come up with it, I come up with it, the judge that tries the case comes up with the rational basis. The plaintiffs are attempting to flip that burden in this case. And the chancellor agreed with them and required that Metro produce a 30B6 witness, or under Tennessee rules, of course, 30.026 witness, who was required to explain all the rational reasons for why this law was enacted, or why there would be a rational reason. And although that helped the case, I think, having to spend hours talking about all the rational reasons, I don't think that that's supposed to be the burden in this case. It could be any conceivable basis, whether it's the one that the legislature relied upon or not.
Well, don't we need someone to testify about conceivable reasons?
I don't think so, because I think this is a question of law. Is there a rational basis? I think that certainly Metro should offer some rational bases, perhaps in its motion to dismiss, but it's really the plaintiff's burden to disprove every rational basis, and that burden should not be shifted to the government. There's no case law supporting that. As to the SP applications of these individuals, these plaintiffs, SP is a specific kind of zoning sometimes that is more detailed than typical zoning. So instead of saying it can be commercial, you could say it'll be a restaurant and it'll have mixed use above it, and it'll be very specific. So yes, there are a few houses around Davison County where the council has rezoned them into SP to have a very specific plan. And sometimes that has allowed a hairdresser to operate in near a residential neighborhood. It's no longer a residential property, though, if you go through this rezoning process. At that point, it's a kind of a mixed use. So you can't compare these plaintiffs who are in typical residences in their home, in a home, very stack of houses on their street. You can't really compare that to an SP where someone has gone and gotten rezoned and no longer has residential zoning. But I'll also add that the plaintiffs asked for residential zoning, did not succeed in having that change in zoning approved, and they never appealed that. Instead, they're trying this collateral attack. So the fact that some people were able to get their houses rezoned is not relevant to creating an equal protection claim. You can't compare a mixed use to a residential and say that's unfair. For all these reasons, Your Honor, we believe that there are a multitude of rational reasons, from protecting residential quality of life to making sure that people have ADA compliance if they're going to have a residential neighborhood. There are lots of reasons for why you would keep these as very separate uses. But I don't think that the court needs to even reach that because, as you discussed and mentioned earlier, this case is moot under the change in policy that the Metro Council has adopted. Thank you.
Thank you, Ms. Fox. Mr. Diggs, your rebuttal. I'm sorry, I can't hear you.
Sorry about that, Your Honor. This is an equal protection case. The Tennessee Constitution makes clear that it guarantees to all Tennesseans equal rights, privileges, and immunities under the law. You just heard my opposing counsel say that we can't bring an equal protection case based on some people being allowed to operate a home-based hair salon while our clients aren't, simply because it's different. It is different. And that's what we're trying to get recognition of. The evidence here shows that there is no difference between Pat Rayner and the home-based hair salon, and for that matter, the thousands of other businesses that are allowed to serve clients at home. Addressing the Norma Faye Piles case, which opposing counsel relies on, in that case, the government made it absolutely clear that the challenged conduct could not recur. That is the voluntary cessation standard. Here, Metro is trying to have it both ways. She said that she believes that the sunset clause in the temporary ordinance means that there would be no provision regulating home occupations once that sunset clause happens. But then she said in the very next sentence that she doesn't think that means you can serve clients at home unless you're authorized. It has to be one or the other. It can't be both. And while this case might be moot, if in fact there were no regulation of home occupations at all upon the operation of that sunset clause, Metro isn't taking a definitive position on that. And that falls far short of the burden in Norma Faye Piles of the party asserting mootness by virtue of its own voluntary cessation to prove that it has mooted the case. Metro has failed to meet that burden. The passage she referred to on page 206 says that the challenger can be asked to show cause for why the case should not be dismissed if it is justified based on the circumstances of the case. Again, in Norma Faye Piles, it was different, where the government swore off forever that it was going to condemn the homeowner's home. Here, Metro will not say one way or the other how to interpret its own sunset clause. Turning to the merits, there is an uncontested record in this case. I highly encourage the court to review our statement of undisputed facts, which is in the record at page 643 through 93. Metro admits all but 2 of our 295 statements of fact. Metro's admission is at the record at page 2257. I would refer you in particular to page 682 in the record. Opposing counsel referred to the organizational testimony of Carter Todd. In that testimony, Mr. Todd conceded on Metro's behalf that there is no evidence that enforcing the client prohibition against Lidge and Pat served any of Metro's interests, except for the possibility, according to Metro, of the fact that there was one anonymous complaint against each of my 2 clients in this case. We took the depositions of several of Metro's code enforcement officers. And again, this is also covered in the record at page 682. All of those officers said that complaints are in fact not evidence of any harm to the residential neighborhood or to public health, safety, welfare, so on. And so based on that record, we're just asking for that record to be credited, which it was not done in the decision below. The Chancellor's opinion, page 24, recognized that short-term rentals, the fact that there are thousands of them and that they can serve clients, constitute a quote-unquote problematic exception to the rule that there are no clients in home-based businesses. But then the Chancellor failed to engage any of the evidence about how that exception is problematic. We are arguing that that exception, the fact that there are thousands of businesses that are exempt from the rule that was enforced against my two clients, is such a problematic exception that is irrational, and it fails to meet the Tennessee standard for equal protection, which requires, as Tester and many other cases pointed out, that there be real differences between classes that are regulated differently, and that the difference between those classes must be germane to the law. Mr. Herbert's testimony, page 689 through 92 in the record, showed that with respect to all of Metro's asserted interests, the businesses that were exempt caused more harm to traffic, parking, noise, trash, lewdness than Lidge or Pat ever could, since they had no impact. Thank you, Your Honors. And I will conclude my argument.
Thank you, Mr. Diggs and Ms. Fox, for your arguments. We will take this matter under advisement. Ms. Kraft?
This Honorable Court of Tennessee stands adjourned.